Greetings. It's been a few days, just dropping in. Of course, my studies are intensifying out of necessity, obviously, to help people see that the laws, statutes, codes, city ordinances, rules, and provisions, and what is perceived to be law isn't law. And for those that do perceive statutes, codes, city ordinances, rules, and regulations to be law, then perhaps those statutes, codes, city ordinances, rules, and regulations were written for you and are meant for you. And I am not going to be one to sit here and try and placate to you that they don't apply to you. Okay, if you believe that over 66 million statutes, codes, city ordinances, rules, and regulations apply to you, then by all means, who am I to tell you any differently? But I know the difference between the law and statutes, codes, city ordinances, rules, and regulations, all right? For the law was not written for a righteous man, okay? And we learn that in 1 Timothy section 9. We learn who the statutes, codes, city ordinances, rules, and regulations were actually written for. So when we look at that, and we evaluate what's been told to us in the good book, and we realize that it's an impossibility for any man to know 66 million plus statutes, codes, city ordinances, rules, and regulations. It's very quickly realized by at least me anyway, that that's not law, because the law is very simple. It's written on your heart. Keep your hands and feet to yourself. Don't do unto others as you want done to you. Love your neighbor as you love yourself. This is really elementary and very basic and simple, and thus the law applies to everybody, for all men are responsible for knowing the law, because the law is so simple and eloquent in every way. It really need not even be mentioned. But unfortunately, in the 21st century, where we have lost touch with reality, we have lost touch with ourselves, and we fall under the seven deadly sins and gluttony and greed and everything else. It's very clear that the law of the Pharisees, Roman civil law, military law, was written for the heathens. It wasn't written for the righteous man. And to further my my extensive studies, and maybe to pass them along to you so you can help see what I'm talking about, John Bouvier, in Institution of American Law, 1882, Volume 2, subsection 3724, Part 4, okay? The law is nothing without equity, and equity is everything, even without the law, all right? Those who perceive what is just and what is unjust only through the eyes of the law, or statutes, codes, city ordinances, rules, and regulations, which are being egregiously misconstrued as law, never see it as well as those who behold it with the eyes of equity, okay? The law may be looked upon in some manner as an assistance for those who have a weak perception of what is right and what is wrong, okay? If you have a weak perception of right from wrong, then it's very clear that the statutes, codes, city ordinances, rules, and regulations were written for you. And they're going to benefit you, and they're also going to protect the men and women that are in the land of milk and honey, enjoying the good life, because they understand the law is written on their heart. And thus, I have no problem with the system anymore. I used to be an enemy belligerent combatant to the system, because I just see the fatal flaws within it. They jump out at me. I was raised very equitable, and I didn't even know the word equity existed until I started studying law. And then it dawned on me. The reason that I am so successful in the courtrooms is because my mother and father did a wonderful job raising me to be an equitable man, even though I never knew that it had a name, and that name is equity. It's what should be done shall be done. You see a need, you fill a need, Derek. If there's somebody that's struggling and you see them, you don't pass them by, you stop and render assistance. And that's how I was raised. And I wasn't just raised that way by my family, but also the community that I was fortunate enough to be brought up in, which was a very beautiful thing. And that's why I love Nebraska. Less people, more freedom. People are down to earth, grassroots, and I really enjoy being brought up there. At first, I thought it was a bloody curse. I was moved out in the middle of nowhere on a farm, and Pop said you're going to do all the same stupid shit any kid's going to do, but you're not going to end up in prison over it. And I never understood that until I got a little older and started to venture back to other states where I had friends and they were all in juvenile hall or jail for doing very ignorant shit. And although I did the same ignorant stuff, I just never got caught for it. So I was able to grow without becoming something that was abused by the system, or someone who's abused by the system for my young, youthful, adolescent ignorance, right? So I'm very appreciative to it after the fact. During the fact, not so much, but after the fact, absolutely love what my family has done for me. So law may be looked upon in some manner as an assistance for those who have a weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted or whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and the spirit of the law. It doesn't get any more crisp than that, ladies and gentlemen. I mean, this should be taught in church every Sunday. Equity exercises an exclusive jurisdiction in all cases of mere equitable rights. That is, such rights are not recognized in courts of law, at the at-law side, right? Most of the cases of trust and confidence fall under this head. Its exclusive jurisdiction is also exercised in granting special relief beyond the reach of the common law. Now, the common law was extremely brutal. People out here today, you know, the gurus that are running around on the internet telling you, oh, you want the common law. I'll tell you right now, those administrators are giving you exactly what you're asking for, and you are confused because you believe that the common law is equity. You believe that the common law is right, just, and fair. And I'm here to tell you right now, the common law was extraordinarily brutal. I can testify to that with all the literature that I've read over the last few years that clearly illustrates that common law was so flippin' brutal that men and women started to discover equity. You know, I found you can never truly understand happiness if you've never felt the depths of sorrow. And so in a lot of this learning that I'm doing, I'm finding myself at first with conflict because I stand with conviction with my thought process. And then as I read, I start to develop and realize that my thought process was in error. And because I can recognize that, now I can change the way I look at something and perceive it and make sure that I articulate it properly in the preservation of justice. You know, so many people say, oh, I won in a court. You didn't win in a court. Justice prevailed. And we need to start identifying it for what it really is. And it's not about winning. It's not about losing. It's about justice prevailing. So we're going to get into a little 17-page ditty, all right? And this is something I've been studying now for a little bit. And I want to read it to you guys because it's important, because it's going to help you out. And there are a lot of people out there that are naysayers saying, Derek, you don't understand, you don't get it. I got a lot of lawyers that reach out to me going, buddy, you are so lost. And I'm saying, hey, I'd gladly meet you in a court of law anytime you want. Anytime you want, any day of the week, I'll meet you in a court. You can bring up your frivolous statutes, codes, city ordinances, rules, and regulations, and I will decimate you at every turn. Because as I stated earlier, those who perceive law but don't realize what equity is are fatally flawed and will absolutely lose with sound doctrines, principle, and logic. Chancellor Henry Gibson from Tennessee doesn't waste a word, ladies and gentlemen. There isn't a sentence in this one paragraph you can explain in less than 1 minute. We're going to read one paragraph together, and I am going to have to stop on every sentence so you get the idea that when these chancellors talk, you can't miss a word. You've got to read it at least 5 times because they're not making a grammatical or word choice mistake. It's absolutely spot on. Here's what I'm getting at. I've already read the long version of subrogation and redlined them. Sheldon's book, Mitchell's book, the guy with P over his name, Pomeroy. It brings me back to the one paragraph in Gibson. I was so blown away by what I read in 2 sentences. I read another 1,500 pages to realize it's all in one paragraph, ladies and gentlemen. It's called subrogation. What is subrogation in general? Have you ever read suretyship? I'm going to test your ability to unlearn what you think you know and relearn what you need to know. That's tough, though. What you have to unlearn is that all transactions are a buyer and creditor paradigm. It's wrong. The devil's trick. There are 3 parties to every transaction: debtor, creditor, and a surety. How do you know you are the surety? Did you sign it? Did you make a payment? You have become always the surety, but not always the debtor. That's the devil's trick. Most of the time, you are not the debtor at all. We wind up being a volunteer surety. Can we get remedy if we pay? That depends. Did you volunteer? Were you under necessity and without recourse? If you don't pay, what happens to you? Nothing? Then bingo. Yes, you were a surety. Now, if it's your daughter and you are collateralized and you collateralized her loan and signed anywhere, and then when she doesn't pay, it damages you, your property, estate in some way, then now you are a real true surety and not a volunteer. The devil is the expert in getting us to be volunteer sureties. We thought we were the name on the birth certificate. That birth certificate is the state. It's never been us. They are the debtor. Solvent or insolvent, I won't venture to guess. I'd rather them say which, if it's solvent or insolvent. See the solvency of the principle need not be shown beyond a reasonable doubt, but will be determined, like all other facts, by the preponderance of probabilities. See annotated code subsection 445 and Thompson versus Watson. This is why one of the first things we do in the declaration of status is release any further obligation to be a volunteer surety for that trust, estate, or name. So the remedy as surety is a glorious thing. If this doesn't show you what Jesus did on the cross, then nothing will. This is the ultimate proof that something very significant outside of Roman civil law, that only the inherent exclusive jurisdiction of equity can see. This is just so important, ladies and gentlemen. Page 84 in Gibson Suits and Chancery, section 962, suretyship, subrogation, substitution, exoneration. We will review the letter to read in judges' chambers, where you'll see subrogation is mixed into the letter. To see the real application, and you'll see what's going on here. Subsection 962, suits for exoneration of sureties. Entire good faith is required between debtor and creditor and sureties. And if a creditor does any act affecting the surety, or if he omits to do any act of duty which he is required to do by the surety or otherwise bound to do, and that act or omission may prove injurious to the surety, or if a creditor enters into any stipulation with the debtor unknown to the surety and inconsistent with the terms of the original contract, the surety may set up such act, omission, or stipulation as a defense to any suit brought against him in a court of law or equity. So that if a creditor stipulates with his debtor in a binding manner upon a sufficient consideration to give further time for payment without the consent of the surety, the latter, the surety, will be thereby discharged. If the arrangement might be injurious to him, mere delay on the part of the creditor, at least if some other equity does not intervene, unaccompanied with any valid contract for such delay, will not amount to laches. so as to discharge the surety. No matter how much time passes without a lawsuit, you are still the surety, for the creditor is under no obligation to press the principal for payment. Two principal debtors. One is the COLB, the Certificate of Live Birth, / the birth certificate. The other is the Social Security number. The Social Security card actually said in plain English, that it is not your Social Security account card. The COLB in BC says the state owns it. These are the principles. So when filling out an SS4 and you are to put in your information, the state is actually using the two separate entities of your COLB birth certificate linked to the Social Security card, but the Social Security card relies on the suretyship of the COLB BC. These two are connected because you put the information down on the SS5. And if I was you, I would check into the SS5FS, which stands for foreign status. Generally, when it comes out to you, it matches the all caps matching the COLB. You volunteered surety for both. However, sureties are not obliged to wait for their principal to bring suit, but are entitled to come into a court of equity after a debt has become due and compel the debtor to exonerate them from their liability by paying the debt. Read that again. Sureties are not obliged to wait for their principal to bring suit, but are entitled to come into a court of equity after a debt has become due to compel the debtor to exonerate them from their liability by paying the debt. Where do you usually see the word exonerate? In law, criminal law, right? What's happening is they're using the word exonerate because their discharge as the surety for the charges under the crime. Did you see Bill Cosby's indictment? It said William Cosby. Then underneath it says Cosby Williams surety. And the moment you see surety, your alarm bells should be going off. I'll just extrapolate when I read this. A private American national acting as surety is not obliged to wait for the birth certificate or Social Security account holder to suit. And the surety is entitled to equity that any time a payment of a debt has become due to compel the principal, birth certificate, Social Security to pay the debt. And if they do not pay the debt, the surety is exonerated from payment thereto. In other words, hey, principal, I order you to pay that. If you don't, I'll be exonerated. What is the remedy? You demand the principal debtor to pay the debt. For if they refuse or fail to pay, you are exonerated as surety. Third time's the charm. Sureties are not obliged to wait for their principal to bring suit, but are entitled to come into a court of equity after a debt has become due and compel the debtor to exonerate them from their liability by paying the debt. So when I add what I put in parentheses regarding due process to the treasurer of the birth county, if a surety requests the creditor to sue forthwith, stating that he will consider himself no longer bound as surety if the creditor fails to do so, he will be discharged by the creditor's failure to sue. If this principal was solvent when the notice was given, but becomes insolvent after the expiration of the time probably required to prosecute the suit to judgment if it had been promptly instituted as requested, you are demanding the creditor sue the debtor, or you'll be exonerated. So who's the creditor in the criminal case? The United States of America? The United States? Send the demand to the USA to sue the birth certificate for those charges. I'll give you 30 days to do so. If you don't, sue the COLB, BC, or Social Security, driver's license, and any other all derivatives, sureties. And if you fail to do so, you thereby exonerate this man for fair, just, equal, and righteous cause. That's theirs. See how you are recognizing that the debtor is the principal and not you? You are claiming yourself just the son, heir, as master of all things, even over the surety, as you are being compelled to be liable if the debtor doesn't pay. That debtor is the independent entity you don't own. That's theirs. The devil's got you in volunteer suretyship contract. Some claim that it's not voluntary. Here's why. Subsection 963, Henry R. Gibson, Suits and Chancery. Frame and form of bills of exoneration of sureties. The bill must allege 1. The fact of suretyship and how arising. 2. The solvency of the principal debtor when the right of action on the obligation occurred. And 3. That after such right occurred, and while the principal was solvent, complainant notified the creditor to bring suit at once on said obligation, or he, the complainant, would stand as surety no longer. And 4. That after such notice, the creditor failed to sue in a reasonable time. And 5. That in the interim, between such notice and the bringing of suit by said creditor against complainant on said obligation, the principal debtor became insolvent. And 6. Should pray that said creditor suit be enjoyed and complainant discharged from liability on said obligation. Number 4 above, or would be no longer liable or responsible, or would consider himself discharged, released, or some equivalent expression. Subsection 964, Bills for Exoneration of Surety, page 756, for address caption, see annotated code, subsection 155 through 164 and 789. Regarding 964, the actual remedy of our Lord coming to bat for you, watch how this works to relieve you. Subrogation is the substitution of one person in the place of a creditor whose debt he has paid under compulsion. Did he say because it's a nice day out and you were feeling charitably generous to just do it anyway? No, he said you have got to be under compulsion. A sheriff's about to evict a man named Juan Valdez. Anyone want to go save Juan? Anyone have any ties compelled to go save him? Are you renting a room in his house so if he gets kicked out, you may become liable? Now, you are under compulsion to do something. Get it? Question raised. Why shouldn't we be interested? Because the rules of equity, the rules of the true sovereign, Yahweh, say equity does not come to the aid of a volunteer. Surety. That's the devil's trick. Now, if you want to go over to save Juan Valdez, you can strike a deal with Juan charitably, but now equity sees your charitable act and calls it volunteer charitable act. A gift you gifted to Juan Valdez, and equity does not come to the aid the imperfect gift. Perfection of an imperfect gift as a volunteer, you are in legal land. Did Juan agree to pay you back or give you capitals from his apple tree? Is there any implicit agreement, or did you give charity because you are a good-natured person? You don't get equity from being charitable, but you are more than welcome to be charitable. Now, a lady in Dade County, Florida, sent a beautiful pleading to the county tax assessor that they have perfected title in the land and require true full accounting on the land patent from the beginning, and the tax assessor had the character to call her up and say, okay, we received your letter and we do recognize you for the full accounting back to the land patent. 2 weeks later, the county tax assessor called back and says, I made a mistake. All the payments on that land for the last 60 years have all been voluntary, under no compulsion to do so. If it's no compulsion to do so, it's voluntary. If it's under compulsion to do so, doesn't mean contract. It just means compulsion. The rest of us aren't. Volunteering doesn't stop you from being charitable. It doesn't stop you from getting subrogation remedy. Marco raised the question over who gets the 2200. Neighbor's house next door is on fire. He's not home. You're under compulsion to put the fire out because your house is liable to burn down. So the fire department shows up and says, no, we're sorry. We can't put out the fire because he didn't pay his property taxes and he owes $2,200. We can only put out the fire for those who paid property tax. Start pumping water. Boom. You'll pay it under compulsion, right? I'll go ahead and pay the $2,200, put his house out, because the probability of his house burning and starting my house on fire is a great risk to me, and I'll go ahead and pay the $2,200. I'll be right back with that check. Now, insurance show up to pay the house that burned down. Who gets the money? You do, because you subrogated as security, because you paid under compulsion. We may be limited to what you paid, but we'll find out what you are entitled to. You definitely take priority over the creditor, over the mortgage company, over the beneficiary on the insurance policy of acting under compulsion. The one compulsed to do so subrogates the right of the creditor. You subrogate to the creditor. The creditor is subrogated to you. The creditor takes a back seat. You have substituted for the creditor. Never call yourself a creditor substituting in. You are not the creditor ever. You are the subrogee. They are the subrogor. You only say you are the subrogee. I am under compulsion in this matter. I made a payment under compulsion, not being liable primarily, therefore, into whose rights, as to the collection of the debt, he thereupon succeeds. As the merger. It's a merger because you, though you were the debtor, yet you are the subrogee, and the subrogee has superior priority right over all parties. Back to the COLB in BC, the birth certificate and the certificate of live birth. Have you been making payments your whole life under compulsion to do so because of that birth certificate? Do you have a right of subrogation against the birth certificate? Does your right of equity have the right to be subrogated, to be the subrogee of the certificate of live birth or birth certificate for the creditors of the certificate? Do you have priority paramount first superior in order of time as subrogee? Brush up on these definitions. Redemption is a collateral security mortgage and or performance for contract. Surety. A surety is one who, at the request of another and for the purposes of securing to him a benefit, becomes responsible for the performance by the latter of some act in favor of third person, or hypothecates property as security, therefore, Civil Code, California. Suretyship. The contract of suretyship is that whereby one obligates himself to pay the debt of another in consideration of credit or indulgence, or other benefit given to his principal. The principal remaining bound, therefore. It differs from a guarantee, i.e. this, that the consideration of the latter is a benefit flowing to the grantor. This is Georgia Code 1, subsection 82. Past consideration is really no consideration. Consideration must be something promised or performed now or in the future, but it cannot be something you did in the past. For example, instead of asking you to quit smoking, your rich uncle promises to give you $1,000 for helping him last year when he was moving. A couple of weeks go by, but your uncle does not give you the money. Unfortunately, there is not too much you can do because the promise to pay you in consideration for your good deed last year is a past consideration. So the agreement is unenforceable. 4 facts about consideration contract law requires you to know. Consideration. If they give you their guarantee, any guarantee is worth something. Can you sell it back to them? If you could, what's the price you'd sell it back to them for? How about just stipulation to keep your account open, going as per my stipulations? Subrogations, the substitution of one thing for another, or of one person into the place of another with respect to rights, claims, or securities. Subrogation denotes the putting a third person who has paid a debt in the place of the creditor to whom he has paid it, so as that he may exercise against the debtor all subrogation, 1,117 substantial damages. The rights which the creditor, if unpaid, might have done. The equity by which a person who is secondarily liable for a debt and has paid it is put in the place of the creditor so as to entitle to make use of all the securities and remedies posed by the creditor, in order to enforce the right of exoneration as against the principal debtor, or of contribution against others who are liable in the same rank as himself. That's BISPEQ. Legal subrogation, the term used when a person who doesn't owe the debt pays it and then is entitled to remedies offered by the creditor. This term is the device that forces the person who owes the debt to pay it. Substitution in civil law. In the civil law, the putting one person in place of another, particularly the act of a testator in naming a second devisee or legatee who is to take the bequest either on failure of the original devisee or legatee, or after him. In Scotch law, the enumeration or designation of the heirs in a settlement of property substitutes in an entail are those heirs who are appointed in succession on failure of others. Right of subrogation, the liability to switch collateral with the same minimum value and marketability. Exonerate, to lift, remove the stain of being called out for blame, liability, or punishment. It is more that just freeing an accused person of the responsibility for a criminal or otherwise illegal or wrongful act. It is publicly stating that this accused should never have been accused in the first place. Refer to acquit and exculpate. See exoneration, the removal of burden, charge, or duty, particularly the act of relieving a person or estate from a charge or liability by casting the same upon another person or estate. Louisville and in R. Cove versus Common, 114 Kentucky, 787-71, Southwest 916. Bannon R. Burns, CC 39 Fed 898. A right of equity which exists between Black Law Dictionary, 2nd edition. Article 2, suits for subrogation, subsection 964, suits for subrogation and substitution, subsection 965, form of bills for subrogation and substitution, and subsection 964, suits for exoneration, subrogation, and contribution. 756, bill for exoneration of surety. For address and caption, see annotated code subsection 155 through 164. Claimer / complainant respectfully shows cause to the court that on February 1st, 1903, John Doe executed his note to the defendant for $1,000, due 1 year after date, and complainant signed said note as surety. That John Doe was the then solvent and continued so solvent until on or about April 19th, 1905, when his stock of goods was totally consumed by fire and was wholly uninsured, his loss being about $5,000. That on March 1st, 1904, complainant notified the defendant in presence of a witness that he would not stand as surety for John Doe any longer, and request the defendant to bring suit on said note at once, or he would consider himself discharged. Complainant a few days afterwards wrote to the defendant to the same effect. That, notwithstanding said notice, the defendant failed to bring a suit until the second day of the present month, May 2nd, 1905, when he sued complainant and said John Doe in the Circuit Court of Anderson County, where said suit is now pending. If defendant recovers a judgment on said note against said Doe and complainant will have the whole of it to pay, as said Doe is totally insolvent and has been since April 19, 1905. The premises considered, complainant prays, first, that subpoena to answer issue and see annotated code section 158 through 164, and second, that the defendant be enjoined from further prosecution of said circuit court suit and from attempting to collect said note in any other way as against complainant, and that at the hearing said injunction be made perpetual, and 3, that complainant have such other further general and with particular specificity claim equitable remedy upon which relief shall be granted as the nature of such case shall require, and whereas this is the first special noble command to require by imperative obligation the injunction for this case. And this is first, middle, last counsel, annex affidavit, see annotated code subsection 164 through 789. Suits for subrogation, subsection 964. Suits for subrogation and substitution. Subrogation is the substitution of one person in place of the creditor, whose debt he has paid under compulsion, not being liable primarily therefore, and to whose rights as to the collection of that debt he thereupon succeeds. So, whenever a surety or other person secondarily liable discharges a debt, he is entitled as surety to the benefits of all collaterals or liens which the creditor held as surety, and the person secondarily liable is entitled to be subrogated to the right of the creditor against the persons primarily liable. In such cases, equity regards the payment by the surety or other person secondarily liable as equivalent to a purchase of the creditor's right, equities and collaterals as against the debtor primarily liable, and the court will treat such payer as an assignee of the creditor to that extent, so a creditor is entitled to the benefit of any indemnity or collateral security given by the debtor to his surety, where, in any case, one not primarily liable pays a debt or discharges an encumbrance or lien, being under legal compulsion so to do, he will in equity be substituted to all of the creditor's rights against the person primarily liable. 1. The following are the most usual cases of substitution and subrogation. 1. Where surety discharges the debt or obligation of his principal. 2. Where a co-surety pays a judgment that is a lien on the other surety's land. 3. Where anyone not primarily liable pay the debt or discharge the obligation of the one primarily liable. 4. Where a purchase for his own protection discharges an encumbrance on the purchased property. 5. Where a junior encumbrance for like reason pays off a prior encumbrance. 6. Where a person advances money to discharge an encumbrance on an agreement that he should succeed to the rights of the encumbrancer. 7. Where a devisee, heir, or legatee satisfies a debt against the estate for which others are equally liable. 8. Where any person for his own protection or the protection of some interest here represents pays a debt for which another is primarily liable. And 9. When an insurance company pays in full a loss it thereby becomes subrogated to the right of the insured against the party causing the loss and against other insurers. Subsection 965, form of bills for subrogation and substitution. The following bill illustrates one of the most common cases for subrogation and substitution. Bill for subrogation and substitution. For address and captions, see annotated code subsection 1SS through 164. Complainant respectfully shows to the court that on June 3rd, 1903, the defendant John Doe borrowed $1,000 from the defendant Richard Rowe, and to secure the repayment thereof, he executed to said Richard Rowe a note for said sum due 1 year after date, with complainant and defendant Henry Doe as sureties. That when said note became due, suit was brought thereon by the defendant Richard Rowe against complainant and the defendant John Doe and Henry Doe, and judgment recovered, which judgment complainant was compelled to pay on September 30th, 1905, the sum he so paid, being $1,103, including the cost of the suit. 3. That the defendant John Doe applied the said $1,000 borrowed from defendant Richard Rowe to the purchase of the following tract of land, described it here, but took the title in the same of his son, the defendant Henry Doe, who claims it as his homestead. That about the time suit was brought on said note, as aforesaid, the defendant John Doe assigned and transferred to the defendant Richard Rowe as further security a note of hand for $300 executed to said John Doe by the defendant George Jones, and now due and wholly unpaid. That the defendant John Doe is insolvent, and that the defendant Henry Doe has no visible property subject to execution, except said tract of land, which he claims as his homestead. Complainant charges and avers that said purchase by defendant John Doe in Henry Doe's name was in fraud of creditors, and to hinder and delay them, and that said Henry Doe aided his father therein, and agreed to deed said land to him when called on to do so, and in the meantime to hold it for him. The premise considered, two complainant praise. 1. That subpoenas to answer issues, see annotated subsection 158 through 164. And 2. The complainant be subrogated and substituted to all the rights and collaterals of the defendant Richard Rowe as against the other defendants, that said tract of land and said note made by the defendant George Jones be held liable to reimburse complainant for what he paid on said judgment and interest therein or thereon. 3, that the transfer of said land to Henry Doe be declared fraudulent and void, but if that be not done, that a resulting trust in favor of John Doe be declared thereon, and complainant declared to have a lien thereon by virtue of the premises. That defendant John Doe and Henry Doe be enjoyed from transferring or encumbering said land, and that an attachment issued and be levied upon it to secure complainant's claim. And 4, that complainant be given a decree for the amount due him from the defendant John Doe as principal, and for the defendant Henry Doe as co-surety on said $1,000 note, that a decree be rendered against the defendant George Jones for the amount due on said note made by him to be collected by execution, that said tract of land be sold on a credit of a 6-month and in a bar of redemption, and its proceeds, along with the proceeds of the decree against said Jones, be applied to the satisfaction of the decree in favor of the complainant. 5, that complainant shall have such further and other relief as the nature of his case shall require. This is the first application for an injunction and attachment in this case. J.W. Montgomery, Solicitor, Annex Affidavit, see annotated subsection 164 through 789. back to Marco's question regarding the 2200. Are you entitled to only 2200 or to all collaterals held as security for the house when you prevented it from burning down by paying your neighbor's taxes so the fire department would put out the fire? Get this. You are entitled and have a right to demand the benefits of the collaterals, securities, liens the creditor has as security and the full accounting. That's the merger of the liens and the person secondarily liable. He uses that term for a reason. Use his words. We are under compulsion, compelled to be here today because if the debtor doesn't appear today, I am secondarily liable. Therefore, the purpose by my visit is to express the intent to claim my right of subrogation as subrogee, with the superior capacity to substitute the creditor and sit on the plaintiff's side with the bank. The son and heir as master over all things. A person is a thing that has power over even the private American national who in your society receives by imperative obligation that peaceful judgment owed through the eyes of equity, mistakenly called civilian due process of law, where we seek to uphold our private core judicial rights, and with dominion over, above, and beyond giving voice to, for invoking the right of subrogation, substitution as subrogee, if compelled to do so. If I lose any dominion, powers, rights, titles, interests, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel security, trust residuals, trust residue, baggage effects, rents, profits, and proceeds, and assets, or money, be it that that of account or exchange, if there are any repercussions, equitable or lawful, any whatsoever, you mark the credit bureau name that sounds similar. Remember the doctrine of idiom sonum. If it sounds the same, it looks the same, it must be the same. You got to rebut that. They're two separate things. To my special chosen set apart calling under Yahweh to make this man responsible or allegedly liable for any sin, trespass, claim, or charge, then this son, heir, and master of all things requires that fair, just, equal, and righteous judgment called the great law of peace to judge over the right of subrogation within peacetime judgment under Yahweh, called by publicans civilian due process of law, entitled to all the securities and collaterals, because after all, they're supposed to be administering the grace of the Heavenly Father, ladies and gentlemen. Why be a belligerent man or woman with anyone? No need for that. Be friend to all. It's just business and nothing personal. Do you know how to do business? Yeah, I agree with you, buddy. So, I'll leave you with that, and we'll come back and do a second part of this. I'm going to get something, wet my whistle, and of course, have myself a cigarette, my one sinful pleasure that I enjoy, and I don't even know that I enjoy it, but it's a habit now, so is what it is. But I'm going to step out and have a cigarette. We'll get back to subrogation, subrogee, the rights that you have, being secondarily liable. I just want to share this with you guys. It's very, very important. I had somebody get a hold of me today who was just, they're like, Derek, we just don't see things your way, and you don't have to. You don't need to. And he says, well, what proof do you have that any of this works? That the stuff from over 200 years ago, and furthermore, that was executed over in England, and what proof do you have that it works here? Well, ladies and gentlemen, I don't have any proof for you, except for the 14 cases that I've been involved in, and miraculously, through the strength of the Heavenly Father, we've been able to prevail. My eyes have been opened. I see a different side of the law, if you will, through the eyes of equity. And once you go down this road, it will forever change your life. I'm always looking for the positive way to make sure that everybody's made whole and that everybody's rights are protected at all costs, even if it means sacrificing my own liberty and freedom to ensure that everybody else is made whole. At the end of the day, I want to make sure that everybody that is participating is made whole. That's the goal. That's the end game, to make sure that we're our brother's keepers, and that our friends, our neighbors, and even our agents and agency are made whole at the end of the day for the wonderful jobs that they're doing. Now, I used to have a lot of resentment towards the system. I mean, so much so that my blood vessels would be popping out of my neck in some of my videos. I mean, I would bust capillaries in my forehead and in my eyes because I was so angry. That's how pissed I was. And nowadays, I'm just so relaxed because it's really that simple. It really is. Just understanding that they're supposed to be administering the grace of the Heavenly Father, and that your private trust really doesn't matter to them. Although having a private trust in place is really good, but they are trustees of the people. 63 Charlie Am Jurisprudence 2D very clearly lays that out. We don't need any more further explanation. So it's really a matter of whether or not they're going to deny the trust. Do you disclaim the trust? Do you deny the trust? And that's really a double-edged sword, because at that point in time, if they disclaim the trust, now they're taking their income under false pretenses. They're not doing the job that the Heavenly Father gave them to do, which was to administer the grace of the Heavenly Father. Now, for those of you that don't want to lean towards equity, there's no problem with that. Enjoy your 66 million statutes, codes, city ordinances, and rules and regulations. After all, I once tried that as well. And every time that I would come with 5 or 6 statutes or codes or city ordinances that were in my favor, a prosecutor would come with 24 that were the complete opposite. And I quickly learned that in the realm of statutes, codes, city ordinances, rules, and regulations, that's intentionally created to create controversy, because that's how they feed on you. That's how they make their credits on account, by manifesting misery through confusion. So if you continue to go down the at-law in rem side under martial law, military rule, more power to you. Good luck. It's much easier to go to peace and stand in equity than it is to fight the military, who is a master of deception and manipulation. So much easier to be in equity and just to see that what should be done shall be done. What's right, just, and fair for everybody involved. And appoint them under the Power of Appointment Act as trustees to handle the estate. Now, I could go into Title 26 and I could talk to you about 2203 and who the executor is and why they have a tax liability for accessing your estate, but that's for another time. That's for another place. And that's at the at-law side. And it's very powerful. So if they try and steamroll you in equity, or they try and steamroll you at the at-law side, I can show you how you can put all the tax liability on them. And remember, Al Capone murdered 31 people, and he went to jail for tax evasion. That's what he went to jail for. If that don't tell you something, I don't know what does. I'll tell you this much. All those agents and agency, through Title 26, are 100% liable for manifesting a charge against the estate. And I can show you that too through Title 26. But today, I want to focus on subrogation. I want to focus on equity. So thanks for joining me, and we'll be back soon.